She is the author of the book named Cyber Law Research Articles and is a top cited author in the SSRN Online Research Journal. Madam, we are delighted to have you with us today and eagerly await the knowledge that you have to impart. The floor is yours.
Hi, nice evening. So today my topic will be the challenges. Under the challenges faced by the intellectual property law regime in the digital era, my topic is future of protecting IPR in digital platforms and to give recommendations and opportunities. So when you take intellectual property law, actually we have divided, myself and Tisha have divided the topics. Today I'm talking about copyright challenges. So when you talk about copyright in the digital era, so this is the internet is a glorious environment where information flows freely, where the right to know is a given, where scientific collaboration is easy, where you can express your opinion without censure, and where free competition allows you to set up an online business that knows no boundaries or no borders. So there are a whole heap of issues arisen in this area. I think previous lecturers, they discussed on the issues, but without elaborating, mentioning the issues, I can't give the recommendations. It's easy for me to go one by one. So we have to reconcile that which is position, which is portion, with that which is poison. So we'll see what is poison in the internet, right? So when you talk about copyright issues in the digital era, we have to fire the bad actors and protect the owners and authors of the copyright. So there is enough and even larger and more pressing issue in the digital era in bad actors. So one challenge, like when you talk about digital platforms or the internet, there are a whole heap of digital platforms like websites, blogs, social media like Facebook, Twitter, Instagram, TikTok, Facebook, many things. And also the apps. There are a whole heap of apps, games. So through via all these things, the copyright is violated. And then we'll see how the internet is now a major global data pipeline through which large amounts of intellectual property is involved and is moved. As this pipeline is increasingly used in the mainstream of commerce to sell and deliver creative content and information across transnational borders, issues of intellectual property protection for the material available and through the internet have taken to a great importance. So copyright law provides, but we more than copyright law, because copyright law has a small issue, because when it comes to Sri Lanka Intellectual Property Act number 36 of 2003 or any other act, it has a territorial nature, enforcement problems. So there are a whole heap of things. So firstly, much of the material that moves in commerce on the internet is works of authorship, such as musical work, audiovisual work, multimedia work, movies, software, database information, and so on and so forth. There are a whole heap of things we have to consider when it comes to analysis of the challenges. Secondly, we have to see, because of the very nature of an electronic online medium requires the data be copied as it is transmitted through the various nodes. As an example, when the data is transmitted through an online platform, there is a cache memory involved in that. Technicality is involved that. There may be artificial intelligence involved in that. So we have to address all these problems. Otherwise, we can't stop this problem, or we can't curb this piracy through the internet. So there are a whole heap of things to be considered. So when you talk about traditional copyright law, copying, distribution, creation is prohibited. All tangible, right? So in the nature of the internet, however, is such that it is often difficult to know precisely whether a copy of a work has been made, and if so, where it resides at any given time within the network. As an example, I make a video. Imagine this lecture. You all record it. I don't know, without my knowledge, without the consent. You make it and you stream it in the YouTube. So you get 100,000 views, and you tend to make money out of it, which is prohibited, and also how to deal with it. Who has recorded? Who has uploaded? What is the platform? So who is having the liability? All these are challenges in the present legal regimes, right? So when copyright material is streamed or published or whatever, they are technically, they go by packet switching, by way of packets. So, and the packets are sent as discrete units. So, as these packets pass through the random access memory of each interim computer node in the network, are copies of the work being made. So, how can you deal with it? Because RAM is technical. So how can you deal with it? So I'll give you a small example about loading a computer program into a RAM of a computer and what happened in the courts. It is MAI Systems Corporation versus Peak Computers. In this case, what they have done was that computer program was loaded into the RAM of a computer and constituted the making of copy, like we do in other things, like we go through websites and we download things. Lot of things are done the same way. They also have done the same thing. So the court held that loading a computer program into the RAM of a computer constituted the making of a copy within the purview of copyright law. Unfortunately, there are no held cases in Sri Lanka with regard to cache memory. So in the other slides, in the other topics, we'll discuss on it, how to deal with those. So this case has been followed by a number of other courts. This is this has a floating jurisdiction. So cache memory, if you download something in a cache memory, it is a offense and we have to deal with it. And also there are different solutions given by the lawmakers, the technical people with regard to this problem. So WIPO Copyright Treaty, which we are a member, Sri Lanka is a member, and also WIPO Performance and Phonograms Treaty is there to deal with the internet contents. So unfortunately, we have not been a party to WIPO Performance and Phonograms Treaty. So one legal challenge could be overcome if we become a party of the WIPO Performers and Phonograms Treaty with regard to these performers things like streaming, cover songs, mashups. So there are a lot of in violation of copyright when it comes to music industry. Sound recordings, torrents, lot of things. So lawmakers have to be alert. Actually, I have spoken with regard to this matter with World Intellectual Property Organization and NIPO. So still we are not a party in the Performers and Phonograms Treaty. So we have to be a party in order to have our own jurisdiction. So as you know, I don't know whether you know or don't know, but you see, it is a international law. Copyright or intellectual property, even though it is having the jurisdictional issue, World Intellectual Property Organization is the main organization which make laws to the whole world. So if we are a party of a specific treaty, we can incorporate those laws in our own statutes. So one solution to overcome this problem is lawmaking authorities or the government has to have their own policies with regard to ratification of all these laws. And also European Union, actually they have a very comprehensive solution. European copyright directives on the harmonization of certain aspects of copyright and related rights in the information society. They are the fastest in the world when it comes to IP, cyber law, anything. So they have taken solutions by way of policies, and also there are a lot of technical solutions made by these countries, and also they are taken at the moment. They are instituted at the moment. So European copyright directives on the harmonization of certain copyright issues. As an example, when you go to EU, if you go to EU, their content is not visible to everyone unless it is in the public domain. As an example, it is called the digital single market. They call their copyright things, they call their things in a single market. They are dealing with themselves only. Right? So it is very easy. It's a harmonized legislation. Everybody use the same directives. So countries like us, especially Asia, our legislations are separate. As an example, I'll tell you, I have a lot of experience in that. Now it's been 20 years as a IP lawyer. So one day, one designing company, actually it's a very, very popular designing company. They came to me one day, and what happened was, they are unique in their sari designs. So they make handmade sari designs, not batik, but sari designs one at a time. So they have separate designers, they invest a lot. Sari will cost about 50,000 minimum, 50,000 and above, right? So what really happened was, it has been in the Facebook. It is in the Facebook. So they have a separate page for that. They market online. Instagram photos are there. So they outsource the models, and they display their saris by using their own models. And what happened was, Indian company, they have taken the saris and they have machine printed the same thing. While they are having one piece here, they have machine printed thousands of saris. This sari is about 50,000 rupees. The other sari is about 3,000 rupees. So it circulated all around Asia. Those saris came to Sri Lanka also. Because of the territorial nature of the copyright law or whatever intellectual property law, they had to go to India and deal with it. We couldn't handle it from this court, Sri Lankan courts. So there are barriers and challenges in this regard. But EU has overcome that problem, having a digital single market. Even South Asia or Southeast Asia, we can have that. So the lawmakers have to deal with it. So we'll see whether interim copies made during the course of transmission constitute a infringement. So this is bit of a tricky area. So as a result, whether interim copies made during the course of transmission could be an infringement is a question. So there are many other various court cases held with regard to this matter. Yes, it is an infringement, but there are a lot of elements to be discussed in that. Who make the copy? What is the intermediary? Like, what is the platform? Those things have to be considered in that. So, specifically Article 7, 11, 16 of WIPO Performance and Phonograms Treaty, it makes the space to have the own jurisdiction. So, even if we have the proper statute with regard to internet streaming or caching or copying or whatever, we'll be having the statute, the law to Sri Lanka. So that is one problem. And the other problem is the anonymity. Anonymity has to be dealt with lot of caution, because as an example, I have lot of examples in this subject. So anonymity in the sense, one day one film director, he came to me 1 week back. He came to me and said that one of his popular films has been uploaded in a site and it has couple of million views, right? So what really happened was that we went through the website and the author was anonymous. The person who uploaded the film was anonymous. So what we have to do is that it has to be dealt with a cyber forensic investigation first. Even though it is dealing with copyright, firstly we have to do a cyber forensic investigation, and then we have to see from where it has been uploaded, and then we have to get the person who has uploaded. But unfortunately, with the fair use concept, all these anonymous authors, or even though the author is clear, they will come up with the fair use defense. I don't know whether the previous lecturers told about the fair use defense. Fair use means there are exemptions for the copyright infringement. As an example, I produce a film. Producer has the rights. So no one can copy and sell it, but I can download it and watch it for myself. So that is allowed. Personal use is allowed. Educational purposes, you can take a substantial amount of copy. Photocopying a book and give it to my students is not infringement. Archives, not infringement. Here, in this particular case, the film is uploaded, but you can watch it free. So what is the legality in that? The legality in that is they will advertise. They will advertise in those websites and then get money, which comes under unfair competition. Right? So there are a whole heap of cases not in Sri Lanka, but in other countries, especially America. They are very concerned about it. So they deal with their judges, their lawmakers, their judiciary. Everybody deals with all these. And you can definitely sue the person who uploaded this. With regard to anonymity, if you use proper cyber forensic tools, you can trace the um, person who uploaded it. The second thing in anonymity is this particular anonymous person uses a VPN. Then how can you deal with it? I faced a personal problem. Same thing happened to one of my things, and he has uploaded my document through a VPN. So even the law enforcement authorities couldn't deal with it, but actually we found the person, found where it has been uploaded. The VPN was belong to America, so the person who has uploaded was having the help of this VPN. So if we do further investigations, of course the government has to help us to write to the VPN, the owner of the VPN, I mean the country, and then we have to get the disclosure of the name of the person who is anonymous. But still, Sri Lanka is not up to those standards, and the awareness is lacking in this country with regard to this issue. So other countries, of course, they have very strong legal background, and also technical background is involved in other countries. So multiple parties involvement of a platform. So when you talk about Facebook, I take some photographs of a person X, and imagine he's a photographer. I want to put it in Facebook. So when it comes to Facebook, if you see the policies of the Facebook, I don't know whether you have read them. All the documents, all the data which is uploaded in Facebook belongs to Facebook. So problem is over. They have given a proper stand to the copyright of the whatever the data. So even if we institute the case by way of their terms and conditions, we are bound by the Facebook terms and conditions. So make sure that you can't claim copyright for whatever the content in the Facebook. So you just go home and read today, because no one knows that. So that is also one thing with the social media and intermediaries or the platforms. And also multiple parties are involved. Multiple parties means I upload one thing and the intermediary is the Facebook, and copied by somebody else. There may be 3 different territories. So all these are involved. So there's a very interesting case that is called mafia case. So in that case, when the multiple parties are involved, whenever a user downloads a copy of the work from the intermediary, I mean the platform, and perhaps the operators of node computers through which a copy of work may pass during the course of such downloading. So, which one or more of these actors should be deemed to have made the copy or copies? That is a problem. So, in a court case named Religious Technology Center versus Netcom Online Communication Services, the court refused to hold the OSP liable for the direct infringement. So OSP is nothing to do with that because they only provide the service. Actually, I went for a UN e-commerce forum. Actually, I was the rapporteur there. So in that also, we questioned the Facebook. What is the liability? So Facebook thoroughly said, no, we are only giving the platform, we are not liable for anything. But still, in European Union, the case is not as such. European Union doesn't agree with all these terms. And also, when it comes to these service providers like WhatsApp, Viber, what happens? If somebody uses content, copyrighted material for their selling purposes. Actually, recently I saw there were some WhatsApp messages from one of the sellers of some particular brands, perfume brands. Since I'm a perfume lover, I thought of going through that. So like they are not the proper agents. World brands, world perfume brands. So they are not the sole agents. So how can you deal with it? Like closed source software like WhatsApp. So WhatsApp is of course, it's a closed source software. So you can't do it. You can't sue it. And also they say it's end-to-end encryption. So how can you prove it? So there are a whole heap of issues which has to be dealt by the governments. Government authorities or the policy makers have to deal with that. The most interesting thing in the internet era is now the artificial intelligence. So in the near future, lawyers will be eliminated, translators will be eliminated, but lecturers won't be eliminated, but still they will be in the online platforms, right? So artificial intelligence will eliminate everybody. Why and how? So I'll give you an interesting case which happened to Google. One person called Field came across the Google has a bot. Actually, Google has a bot. Have you spoken to Google? If we ask the Google to do something, Google, can you find me this? It's just like Siri. All these are artificial intelligence. So there are a whole heap of data bundles are involved in this. So copyright material, everything is involved in this. In the Field versus Google, in this it was discussed in greater detail by the court rule that Google should not be liable as a direct infringer for serving up through its search engine. But the thing is, in this particular case, this person Field, he didn't sue the bot. That's what happened. Actually, in actual scenario, in the present scenario, when it comes to artificial intelligence, if we particularly ask the Google's bot, chat bot or whoever, infringed his intellectual property, Google is liable for that. So in our country, we have to be very particular and the laws have to be very stringent. We have to deal with this. And also the judiciary, the lawyers, actually in other countries, There are blockchain lawyers. There are artificial intelligence lawyers. There are IP lawyers. IP lawyers themselves can't deal with this because internet is dealing with lot of things like blockchain technology, digital twins. So there are a whole heap of things involved in that. So there should be experts to deal with this in Sri Lanka, and also there should be law reforms with regard to this matter. So and ebooks. So there are a whole heap of pirate sites in the internet. I don't know whether you know about this Sky Hub. So it is a pirate book site. And there are a lot of platforms, e-commerce platforms, which are dealing with sale of books. Moreover, there are e-books which could be downloaded by artificial intelligence. So that is the worst part of it. So there are tools which download ebooks in the hard memory by artificial intelligence. So what is the legality in that, and also how to deal with it? So when it comes to artificial intelligence, there are a lot of technical methods to deal with it, and like blockchain technology. So blockchain has been found at the moment. Blockchain has been found as one of the most strongest methods, which doesn't involve the human, right? So, and also internet system protocols, which automatically temporarily stores data without human intervention. What is the liability of that? So in order to circumvent this liability, there are reverse engineering processes. There are a lot of things which have been incorporated by other countries. How many minutes do we have?
Yes, Mr. Aridasa, I think the floor was ceded to you at 1:35, and I did not want to disturb you until it was at least 2:05.
Okay. So there are a whole heap of... Sorry?
Sorry, I was wondering if you would prefer if we open the floor for Q&A.
Yes.
So participants can put the questions in the
Correct.
chat box.
Correct.
And once, yes.
So there are a whole heap of things. I don't think I can teach you, I can tell you 1 year, because this is my subject, so I have researched a lot. So yes, you can ask questions.
Yes, it was definitely a very dynamic and engaging presentation. Thank you very much, Ms. Aridas. I think we all learned a lot, especially about these practical elements. So the first question comes from Iqbal.
Yes.
Yes, Iqbal, you can go ahead.
Travini, hi, this is Tisha.
Yeah, Tisha.
Just wondering, hi, sorry to barge in, but I'm
No.
wondering whether since trademarks, copyrights, this whole topic could go hand in hand. I'm wondering whether we could keep the questions until my question.
Okay, then you start, Tisha. It's easy. So at last we'll do the...
Right?
Yeah, that is fine with me.
Yes, Mr. Vedaguru, that's perfectly fine.
Okay.
May I please take a minute to introduce you?